So Fraser, let's start with the big question. Why are you actually bringing this case? I mean, there's a danger it could cause confusion. You know, it's not the perfect directive by any means, but some people would say it's a lot better than it could have been. What are you hoping to get from the challenge?
I think there's a number of sub-questions in that. Firstly, why we're bringing the challenge. Well, we decided when we first saw the draft TPD in 2012 that if that entered legislation, it would be just fundamentally wrong. Wrong for commercial reasons, of course, wrong ethically for what he was doing and what he should have done. And secondly, and probably just importantly for Paul, it is wrong legally. It's a wrong legal premise, and it's gone through a process which is atypical of what a legal process should be for European legislation. But from my perspective, the first elemental part of that response is really important to our business, which is I don't understand, and nor do our customers, or those who spend the time reading into this subject matter, understand why this regulation is cleaved to tobacco products regulation. It doesn't seem to have been based upon evidential fact and a data which establishes the risks which are trying to be mitigated, and it is fundamentally going to disrupt a marketplace which has been able to, without any public sector health, generate 2 million vapers in the UK, over 10 million vapers in Europe, who've taken their own information that's available, made their own decision and concluded the vaping using a e-cigarette device, a tobacco product, is the right thing for them to do. And that's supported not only by that empirical evidence of the users, but also by a significant welter of academic research. And the TPD, when and if implemented, will fundamentally undermine, nay, destroy that.
So, but what gives you the right to do this? I mean, basically, I mean, you make some good points from your point of view as a business. It may not be what you want, but what gives you the right to try to overturn the will of the European Parliament, the European Commission, the 28 member states that have all agreed this through, you know, a legitimate lawmaking process?
Well, that's a valid question. Every citizen or company has the right to expect that the democratic process is followed. If the democratic process was followed, we would not have had this regulation. There has been a circumvention and sometimes an absolute ignoring of the due process should have been followed. And indeed, the due process should have been informed by the necessary information to make sure the regulation and the output of that legislative process was fit for purpose. Neither of those two things have happened, and therefore it's a legitimate thing for us to do, which is to, A, as a citizen, and B, as a European legitimately trading company, to challenge a directive which is patently unacceptable and has not followed due process.
Paul, what's the lawyer's view on that question?
Yes, well, the directive may well have been passed into law by a majority of the MEPs, but that doesn't mean that the MEPs can pass whatever they like. There are important overriding principles that are set out in EU law, in the EU treaties, and any decision to pass new legislation has to be in accordance with those overriding principles, and we identified that the Tobacco Directive and Article 20 in particular don't meet those requirements.
So given that, you know, given that the case is based on an infringement of the EU treaties, what are the main legal arguments you're going to put in front of the court about Article 20 to get them to overturn it?
Well, there are four main grounds to the legal challenge. The first one is that the provisions of Article 20 are disproportionate, and that means that they're too heavy. This is a sledgehammer to crack a nut, and you know, they could have been dealt with in a less restrictive and less burdensome manner. Secondly, that they're discriminatory. They discriminate between tobacco cigarettes and electronic cigarettes, and they discriminate in favour of the tobacco products, which are the more harmful products. Thirdly, these measures could have been dealt with on a member state by member state basis. There's no requirement for these to be addressed on a pan-European basis. It could have been left to individual member states to deal with particular issues as they see fit. And fourthly, that the provisions infringe key treaty principles and key rights that Totally Wicked has. One of the restrictions will be a ban on advertising, and that will infringe key rights that Totally Wicked and other manufacturers have.
So who's going to hear the case, and who will be defending it, you know, against this legal challenge that you're bringing?
Well, the case will be heard by a panel of judges in the European Court in Luxembourg. There will probably be a hearing in about a year's time. It may not happen until the back end of 2015. Before then, there will be an opportunity for Totally Wicked, for the European institutions and any member states that take an interest in this challenge to put in written submissions, setting out their arguments one way or the other, whether it's in favour or against the provisions of Article 20. And those submissions will be filed in the early part of next year. Once we've seen those, then we'll understand what approach the EU institutions are going to take in resisting this challenge, because at the moment they've not played any part in the legal process so far, which has simply been a challenge issued against the Secretary of State in the UK. So we'll understand more the basis upon which they are asserting that the directive is lawful. There will then be an opportunity for the Advocate General in the European Court to give his legal opinion as to whether the provisions of Article 20 are lawful or not, and there will then be the hearing towards the back end of next year. So it will be quite a slow process over the next 12 months, but hopefully by the spring of next year we'll have a better understanding of the different arguments and which parties are seeking to intervene and support or resist Totally Wicked's arguments.
And talking of that, some people say that the Department of Health is supporting this case. Now, that doesn't sound right. What's the story?
They're not supporting the case. What they are essentially agreeing to is this being referred to the Luxembourg courts for a ruling as soon as possible, and they're going to leave it to the EU institutions to make the case. They're simply not going to participate in setting out the arguments, really.
And what do you think the arguments will be? I mean, I've read the Totally Wicked statement of facts and grounds. It seems very convincing to me. How are you anticipating they are going to defend their corner?
Well, it's hard to say because they've not really been part of this legal process so far. The process started off by challenging the Secretary of State's decision here in the UK, and until we get the submissions from the EU Commission in the new year, we won't really know how they're attacking it. They could go into great detail and set out all of the arguments with supporting evidence, or they may simply make very short legal submissions and leave it to the European courts. So we really don't know.
But I think also there's an important point beyond the core legal, which is we have not brought this case because there is some peculiarity in the legal process that we hope to win on. As far as I'm concerned, the arguments are simple and very compelling. And if they're simple and very compelling to me, and they're simple and very compelling to our legal team, and we are able to offer those to objective judges, then why will they not be simple and compelling to the legal team who are asked to make a decision on this particular matter? I think they're going to find it very difficult to make a cogent argument. If they try to frame their argument on due process has been followed, then I think they'll flounder. If they try to make an argument on the fact that this is justified by academic research, they'll flounder.
Well, of course, there was that letter from the scientists who wrote in making many of the criticisms of the directive,
Absolutely.
which you've drawn on heavily in the case.
Indeed, and there's been a lot of misrepresentation. It's actually been a very unedifying process to be witness to. Lots of people aren't aware of just how many shenanigans there have been and how untypical of what they should expect from the democratic leadership. So I think when we get ourselves in front of a court, when we get the opportunity to have those very simple yet compelling and fully supported arguments, it's going to be exceptionally difficult for there to be a counter-argument that picks them up to pieces and undermines what is a very simple, compelling and well-argued argument.
There's a lot of interest in the case. I think there's a lot of people very glad that Totally Wicked have taken the initiative on this. People are asking, how can they help? How can they be involved? So is it possible for them to participate in the formal process? Can they write submissions or affidavits or provide evidence? Or is there some other way in which they can get involved? Let's start with the formal side of it, Paul.
Well, unfortunately, they can't participate in the legal process because the court rules limit that to the current parties, the member states and the relevant EU institutions. Those are the only parties that can file formal written submissions. So there's no opportunity for other interested parties, members of the public, to make any submissions within the court process.
What about outside the court process and the sort of court of public opinion?
Well, the court of public opinion and the emotional court, I think we need to continue to do what we, the collective industry base, but more importantly the consumer base, did so remarkably well in 2013, which was bring to bear their passionate arguments and their rationality to this. And the more people who are informed of our legal case, the more people who are informed of those basic tenets of our legal case, and the more people that recognise this is not just in the sole narrow commercial interest of our business, but actually there is a very strong moral touchstone and there's a very strong basis for what we're doing that touches every single vapour and every single participant in this sector who wishes to see a sector that's allowed to be competitive, that's allowed to continue the innovation and to deliver the products in that environment that the customers need. So the more people who are aware, the greater the base of advocacy, the more difficult it's going to be, I believe, for the European Parliament to not listen to this in the way that they have to. They are legally bound to listen to this objectively, and the more people who are informed of those simple objective arguments, I think the more influence, pressure, call it what you will, be brought to bear, and the greater explicit responses and outputs which will need to be held account to. Yeah. So I think more people get involved, more people read the discussions, get involved in communicating with your MEPs, get involved in your communities who vape, and allow for those arguments to become really resonant with all who have to listen.
And what about the timetable? What's going to happen now? I mean, when's this all going to really hit the news and hit the courts and be in front of the judges? Paul?
Well, the European Court will formally announce this reference in the next few weeks, and it will publish the questions that have been referred in the official journal of the European Union, which hopefully will happen before Christmas or very early in the new year. So that will generate some degree of interest across the whole of the European Union, and that really is the start of the court proceedings. Once that happens, and then the institutions or member states put in written submissions. So that should happen in the new year or in the spring. I think it will be the end of next year, the end of 2015, before we actually have a hearing in Luxembourg, and then the decision may take another 3 or 4 months. So it is going to get very close to the implementation date in May 2016 before this is finally resolved one way or the other. Obviously we're doing all we can to try and expedite matters in the European Court and get this before the judges as soon as possible, but it is likely to be a close run thing.
All right. Looking ahead, let's say we're at the beginning of 2016, the court issues a judgment, goes with your arguments. What should happen then? And because we've got a directive on the books that is then struck down, you know, a gap opens. What should happen next?
What should happen and what will happen? What should happen, I believe we roll back time until 2012 and 2013 and we start again. We recognise that the premise for the regulation for e-cigarettes should not be related to tobacco products, that they sell to the same customer base does not necessarily make the argument that they are one and the same thing and therefore kin in relationship to regulation. So they need their own bespoke regulation. The academic body of evidence that now exists should be listened to and should be considered. There needs to be a fundamental understanding as to why regulation is being applied. What is it there to protect? Take rational consideration that of the information that supports that basic question and put together a regulatory set which protects consumers, informs consumers, and allows these products to have the legitimate space to be available to allow for smokers to have a legitimate choice apart from cigarettes and pharmaceutical nicotine replacement therapy, which is what has happened, which is now potentially being denied. So we start again.
Let's suppose the institutions came back either at UK level or EU level and said, right, that's it then, we're going to regulate these things as medicines. I mean, what would happen next?
Well, interestingly, there have been a number of cases already in individual member state courts where the member states have ruled that the electronic cigarette product cannot be regulated as a medicine under existing medicinal regulations.
Fraser, would you challenge again?
Of course we'd have to. It would be absolutely necessary for us to. It would be an extension of this ongoing case that we have with the European Court. So yes, we'd have to, and we would do.
You'll keep challenging until you get good regulation that's properly and lawfully grounded.
Absolutely. Properly regulated sector is what we strive for, that we try to do our best within currently, that our consumers and customers demand from us, and our politicians and regulators should also be demanding and delivering the legislation to deliver.
And Paul, I just want one final point, because often these cases sort of in the media and by some in the public health community, they get sort of seen as a tobacco industry plot to try and sabotage the entire directive. That's not what's going on here, is it?
No, this is a very focused legal challenge on Article 20, which relates to electronic cigarettes. We're not seeking to overturn the entirety of the Tobacco Products Directive, simply the annulment of Article 20, which will have such a devastating impact on the e-cigarette market and users of e-cigarettes.
I think a company leadership perspective, we're not a tobacco company. We are an independent private company. We can make decisions based upon things other than narrow commerciality. And this decision is something which is based upon something much more fundamental than narrow, totally wicked commercial reasons. It is based upon that premise that we mentioned and discussed previously, which is this is just wrong, it's immoral. And the leadership of this company, which I'm very proud of, has taken that position and put literally our money where our mouth is, which is we're going to take some action which this sector needs, first and foremost. As a consequence, our business will benefit, but everybody else will as well.
Gentlemen, thank you very much for those remarks. Very informative. I found that very useful. Thank you.
Thank you, Clive.
Thank you, Clive. Thank you.